Oh, you hear me? Okay, so you know Rachel Circle and what we do, and we're all about domestic violence, and we picked this year to be mostly about elder abuse. So programs that we're having are focusing on that. And one of the things that we learned in our first two presentations last winter was that financial abuse is the biggest problem with elder abuse of all the types of abuse there are. So today we have Steve Helseth with us from Bolt Law, and he's going to review some of those really important documents that would, if you have in place, would be a really good way of preventing any kind of abuse, especially in the financial area. Very grateful to have him. He's done a lot of speaking, including with the Anoka Caregivers Association most recently, and his knowledge will be very beneficial. So take notes for yourself and for your kids, your adult children. All right. Or whoever is your person that will be taking care of you as you age. And I see there's no one younger here, so I think I'm safe in saying that.
All right. Well, good morning, everyone. What I put out here is, as you came in, there's blue folders. In those folders, there's copies of all the slides I'm going to talk about with some space for notes as well. So feel free to take notes as I go. It's really helpful to process the information, to see it in multiple ways, and be able to jog your memory later what we talked about this morning. So today I'm going to talk about the basics of estate planning and elder law, really what everyone should know, no matter which generation you're in, about estate planning and elder law. Anytime I present, anytime I give a presentation like this, I always have to give this legal disclaimer that is part of the presentation today. I'm not giving you legal advice about your specific situation, but just providing general information. Okay? So keep that in mind. Also, as you're asking questions, I'm happy to make this a conversation, do question and answer as we go. Make sure that your questions are generally applicable so they benefit everyone in the room rather than diving into your specific situation, okay? There's a time and place for that. That's at my office, right? Not here. So general information as far as the meeting goes today. So let's talk about the default rules, okay? So in Minnesota, if you don't have an estate plan in place, Minnesota's nice enough to have a plan for you. Isn't that great? So Minnesota's plan, first off, the question is who? If you passed away with no plan in place, who would get your assets? And in Minnesota, the answer is your heirs at law. So that's your closest living relatives. Typically, if you're married, everything goes to your spouse as part of that process. If you're unmarried, if your spouse passed away, everything goes down to your kids or your grandkids. And if you don't have any descendants below you on the family tree, then we actually go back up the family tree to parents or siblings or nieces and nephews. Okay? So for some people, that plan works just fine. I just described exactly what you would want to happen anyway. For others, that plan does not work very well, right? For those that maybe have a mixed family situation with children from different relationships. Some people may have adopted children, stepchildren, a child with a disability. All of those situations, Minnesota's plan's not going to work very well for those people, okay? The second question is, how do people get the assets? And the default answer is it goes through probate. And we'll talk a lot more about what probate is and how we avoid it as I move forward. So we'll get back to probate, don't worry. Finally, what about the children? I know part of this course was supposed to be me educating your kids or you guys on how to take care of your parents, but also you guys might want to pass some information downstream to your children to say, if you've got minor kids, having a plan in place means they have control over who takes care of their kids if something happens to them. Because the default rule in Minnesota is the court gets to decide who's going to raise your grandkids, their kids, right? So let's talk about some of the basics. First off, understanding probate. most of the conversations I have in my office revolve around probate and avoiding probate. So why do we want to avoid it? Well, typically, the probate process is just the legal process for taking assets in your estate and transferring them to your beneficiaries upon your death, okay? The problem with probate is, first off, it tends to be fairly expensive. The average probate process that I see is between $5,000 and $8,000 to go through probate. So it's a pricey process. The second issue with probate is that it's time consuming. Usually probate takes 12 to 18 months for people to go through that process, and it's kind of a part-time job for whoever's managing your estate at that point in time. A lot of paperwork, a lot of court involvement, unfortunately, a lot of attorney involvement, right? We want to avoid that. And then the third issue with probate is it's public. So if there are people that have an issue with what's going on in your estate, maybe that nosy person in your family tree, the probate process gives them an opportunity to have their voice heard, which sometimes is not a good thing, okay? So how do we avoid probate? This is important. Pay attention to the slide. If you take all of your assets and put them down on a sheet of paper, they're either going to fall into the probate bucket or the non-probate bucket. And if you want to keep things out of probate, guess what? We've got to get everything into the non-probate bucket. So with your bank accounts, if they're owned jointly or if there's a payable on death beneficiary, that keeps them out of probate. With retirement accounts, investments, life insurance policies, it's all about having proper beneficiaries in place. If you've got beneficiaries on those accounts, they don't have to go through probate. With personal property, if we add up your vehicles and all the stuff around your house, and it's worth less than $75,000 combined, it doesn't have to go through probate, okay? And then with real estate, we can use joint ownership or a transfer on death deed to keep those things out of probate. So I call this the piecemeal approach, taking each one of these things and moving it from the probate bucket to the non-probate bucket. And if you get everything onto the non-probate side, your family doesn't have to go through probate. I'm going to pause here for a moment because as we take general estate planning and look at it through an elder abuse situation or a financial exploitation situation, a couple things to look out for, okay? One, joint ownership on bank accounts. There are better tools than adding your kids or adding you to your parents' bank accounts. Okay, and we'll talk about power of attorney. With a bank, you can have signing authority on an account, but rarely do you want to make someone a joint owner on a bank account because when you do that, you give up control over that bank account. They have as much right to that account as you do. Okay? And also, if you add a child to your bank account, or if your parents add you to their bank account, any of your creditors can now go after their bank account. So you're exposing yourself to a lot of extra liability by adding people as joint owners to your bank account. Okay? So keep that in mind. Similarly with the house, adding a joint owner to a house is not a good plan in almost any situation. There are very few exceptions, but joint ownership on real estate should not be done either unless it's with a spouse. Okay? So a couple red flags to look out for when it comes to where do I see issues with elder abuse and financial exploitation. Joint ownership is definitely a space where we see a lot of those issues. Okay? The other way to keep everything out of probate is to use a revocable living trust. Okay? So the way the trust works is you take all those same probate assets and put them all into a trust. And the trust now helps keep everything out of probate. Okay? Any questions about how we keep things out of probate based on those two slides? All right. Happy to answer questions as we get there, so feel free to raise your hand. So let's talk about another tool that I mentioned with that first slide. It's a transfer on death deed. Essentially, a transfer on death deed is a beneficiary designation for your house, okay? And it keeps your house out of probate. So the way it works is you would draft up this document, typically working with an attorney, that says upon your death, You want your real estate to transfer to your spouse, transfer to your child, transfer to the church, transfer to some other beneficiary, right, based on your goals. And after you pass away, that beneficiary would bring a death certificate and one other document to the county, and now the property becomes theirs. So it's a really nice tool. It's a really efficient tool for simple situations, okay? So I tend to like it if we're trying to transfer an interest to a spouse or one child or one beneficiary or a trust. It can be a really good tool for those simple situations. Where I don't like to use a transfer on death deed is where we've got more complications. If you've got 4 kids you want to leave a house to, we typically don't want to use a transfer on death deed in that context. Because what happens is upon your death, all 4 kids are now on the title to that property, which means all 4 kids have to agree on everything that's going to happen with the property along with their spouses, right? When you put your kids on a piece of real estate, their spouses come along with for the ride, okay? So usually transfer on death deeds work for simple situations. Beware of using them in more complicated situations, okay? All right, let's talk about, this is the trifecta, right, of key legal documents that everyone should have in place: healthcare directives, powers of attorney, and wills. So what does a healthcare directive do? It allows someone to make medical decisions for you. You appoint someone, your healthcare agent, to step in and make decisions for you from a medical standpoint if you can't make your own medical decisions. So as long as you have capacity, you get to make all of your own decisions. You're not giving up any rights. But if you become incapacitated, they can step in and make healthcare decisions for you. The second benefit to a healthcare directive is you can tell people how you want decisions to be made. So help guide them through that process of making medical decisions for you, right? So this could be relevant for you as you're talking to your kids about what your goals are from a medical standpoint, or if you have aging parents who you need to step in and make medical decisions for, wouldn't it be nice to have some guidance on how those decisions are going to be made? So within a healthcare directive, we address things like, are they open to experimental treatment or medication? Under what circumstances do they want reasonable measures to help them recover, right? What do they consider quality of life? What happens if they're in a terminal condition or a persistent vegetative state? We can address all of these really difficult topics to make sure that our kids or that you have the guidance you need to make decisions on someone's behalf, okay? There's one example that is maybe a little bit outdated now, but the Terri Schiavo case happened like 20 years ago down in Florida. And in that situation, Terri was in a coma, and her parents and her husband disagreed about what should happen to her. Now, in that situation, Terri did not have a healthcare directive, so nobody had the authority to make those decisions on her behalf. So what did they do? They fought it out in court, right? So they each hired attorneys, and they spent 6 years and over $100,000 fighting over Terri's fate, okay? If Terri would have had a healthcare directive in place, we wouldn't have had any issue, all right? Any questions on healthcare directives? The only other note is I would say be careful about how much detail you put in a healthcare directive, okay? My recommendation is to keep the healthcare directive a little bit more broad, a little bit more open-ended, and then you can provide an informal letter to your family with a lot more specific detail. I just worry about handcuffing your family from making the obvious decision when the doctors read the healthcare directive one way and your family reads it differently. So that's one of the benefits of working with an attorney on something like that, is finding the right level of detail to help guide people, but not run them into problems with interpretation, okay? Second document, we move from medical decision-making to financial decision-making. So a power of attorney authorizes people to make financial, legal, real estate decisions on your behalf while you're alive but maybe incapacitated. Okay? So a couple things to keep in mind with the power of attorney, and especially with this elder abuse, financial exploitation lens, is one, a power of attorney is an incredibly powerful document, right? I mean, you're giving people the authority to make any financial decision you'd be able to make on your behalf. Okay, so it's a really powerful document, which means you want to make sure you're appointing people that you trust to act in that role. Okay? It also becomes effective immediately. So that means these people you're appointing have the authority to step in and make decisions right now, today, on your behalf, even if you have capacity. Okay? Now, I know that sounds kind of scary when I frame it up that way, but I think it's important to understand the power of the document and then also understand why it's so necessary, right? Because without this power of attorney document, if you became incapacitated, you'd have to go through a court process for someone to be able to make those decisions for you. So I think as long as you're appointing people you trust and educating them on what their rights and responsibilities are, it's a very important document to have in place. And it beats the alternative. Yeah.
But does that document cease to exist when the person passes away?
Yeah, so the question is, does that document cease to exist when the person passes away? And that's correct. Yep, that a power of attorney's put in place to be effective during your life while you have capacity. If you become incapacitated, it continues to apply, but then it goes away immediately upon death. So power of attorney is not enough by itself to address what happens upon death. Yep.
Is this the document that you have to have two physicians declare somebody incapacitated before it becomes legal?
No, so the question is, do you have to have physicians weigh in on when this document becomes effective? And no, the power of attorney becomes effective right when you sign it, for the most part. There's one checkbox on the document that would make it something called a springing power of attorney, but I prefer not to use that. In fact, I've never used that document in my practice. So the way a springing power of attorney works is it only becomes effective at the point you're incapacitated, which would probably bring in, physician statements or other proof that you no longer have capacity. The problem with that is capacity is not black and white. You know what I mean? Like, yes, there are black and white examples, but most people go through a long gray area before they no longer have capacity to make their own decisions. And usually this power of attorney is really helpful in the gray area to help mom or dad pay their bills or manage their checkbook or talk to their accountant or financial advisor. So we want this document to become effective right away, so we have it for that gray area. Yep, good question. Yep.
In your experience, is there a certain age that people want to get the power of attorney? And if they're not incapacitated, how is that? Are you both making decisions, or are you completely giving up your?
Yeah, so if I heard it right, the question is there an age where power of attorney makes the most sense, or when you should have it in place? And what happens if if you're making decisions on your own behalf, but then your attorney, in fact, is also trying to make decisions for you? And I mean, really, the age is 18, right? Once you turn 18, you should have a power of attorney document in place. Oftentimes, it'll be parents putting a power of attorney in place for their kids that just turned 18, right? Because they go off to college. If they were to get in a car accident or have some other issue and ended up incapacitated, who's going to step in and make decisions for them? And you no longer have automatic rights as a parent, so you need a healthcare directive and power of attorney to be able to do that. To your second question about multiple people acting, if you have capacity, you get to decide what's in your own best interest. And so if your power of attorney, in fact person, is doing things you don't agree with, you are still in charge. You can revoke the document, you can remove them from acting in that role if they're not working with you the way you want them to. Okay? So at the end of the day, you are still 100% in charge of your own decisions, even if there's a power of attorney, as long as you have capacity. Okay? Any other questions on that?
Are you saying then that there should only be one power of attorney, or could you, for instance, have two children? Could you have two children listed as
Yeah, so the question is, how many people can you have appointed as your attorney in fact under this power of attorney document? I'll say never because I feel strongly about it. I never recommend appointing 2 people with the same level of authority because, one, I've never seen that be more efficient for families. As I work with multiple executors, multiple attorneys, in fact, every time it's more work for me and more work for the family because there's just more people involved in every single decision, more signatures required in every scenario. The bigger issue, though, is if those 2 people don't agree for one reason or another, now we're stuck. Now the document doesn't mean anything because we've got 2 people with equal authority that can't make the decision. And now we've got to get courts and attorneys involved again. So my preference is to list a batting order on the documents, right? You'll have your primary attorney, in fact, your second option, and your third option. So that way the document's flexible enough. If something happens to your first option, you've got option 2 and option 3 waiting in the wings. But it doesn't put us in a situation where we have 2 people at the same level of authority. Okay? And the other nice thing about that is this applies to healthcare, power of attorney, wills. Having that batting order doesn't prevent the kids from working together. They can still work together all they want and help each other out and give input on decisions. But at the end of the day, we have one person who can make the final decision or sign off on the final decision. Okay, so that's a better approach. Yep.
Let's say you had 3 people set up as power of attorney. If something happened to that first person, does it automatically go to that second person?
Yes, if something happens to the first person in line on a power of attorney, it automatically goes to the second person. If something happens to number 2, it automatically goes to number 3. So the documents are built to work as long as one of the 3 people is still alive and able to help. So we like to build that flexibility into every document we draft with at least 2 people, but usually 3 in order. So as I mentioned briefly, the alternative to a power of attorney or a healthcare directive is a conservatorship or guardianship process. So if you don't have those 2 simple, easy documents to put in place and you become incapacitated, now your family has to go through a guardianship process to decide who's going to make medical decisions for you, or a conservatorship process to determine who's going to manage your estate on your behalf, manage your assets, pay your bills, take care of your bank accounts and your retirement accounts. The problem with these procedures is that they're incredibly expensive. I mean, right, the courts are involved again, so we're talking thousands of dollars. Secondly, it creates an ongoing relationship between you and the courts, or your family and the courts, year after year after year. With a conservatorship, you need to report back to the courts with an accounting every single year, okay, until the conservatorship goes away, which could be when the person regains capacity or when the person passes away, is when the conservatorship's no longer valid. Similarly, with a guardianship, you've got to file a well-being report with the court every single year. So both of these situations create that ongoing relationship with the court, extra fees, extra expense, extra hassle, versus the 2 simple documents, healthcare directive and power of attorney. Okay? Any other questions on that? Guardianship, conservatorship. I would also say the guardianship conservatorship process can be a really difficult process too, because right, you think about you or your parents or your sibling who has diminished capacity or they're struggling from a capacity standpoint. We've got to bring them into the courtroom and question them in front of the judge to prove whether or not they have capacity. So it's just a really difficult, sensitive thing that most people don't want to be part of a public court process. Okay? So help get those simple documents in place so we don't have to worry about conservatorships and guardianships. Let's talk a little bit about trusts. Okay? So first off, there are some key people that come along with trusts. The settlor of the trust is the person creating the trust. So some people call it a grantor or a trustor or a settlor, but the bottom line is that person is creating the trust. So let's say that's you in this scenario. You want to create a trust for your assets to protect them, keep them out of probate. You're the settlor. The trustee is the person you're appointing to manage those assets on your behalf, and usually that's still you during your life. Right? You don't need to give control over the assets to someone else if you're still alive and you have capacity. But if you pass away, if you become incapacitated, oftentimes you would have a child or a spouse or a friend or family member take over as the trustee to manage things either on your behalf while you're living or get the assets to your beneficiaries when you pass away. So that's the trustee role. I think that's most akin to like an executor under a will. You'd have a trustee under a trust, okay, the person in charge of that document. And then the beneficiaries. Who do you want to benefit from the assets at the end of the day? During your life, you are the beneficiary. Those trust assets are only going to be used for your benefit, right? Or for the benefit of you and your spouse, typically, if you're married. So during your life, you're the settlor, you're the trustee, you're the beneficiary. Upon your death, you're appointing someone else to manage things as the trustee, and oftentimes some other people or charities to receive the assets when you're gone. Okay? To see that in another light here, so same thing, we've got the settlor creating the trust, appointing a trustee to manage things for the beneficiaries. Same idea, just different picture. Yeah.
Just to clarify, when you say the trustee, are we considering if you're married that there are two spouses, that when one predeceases the other, that the surviving one has all of the control and power, right? Until both are gone? That's what I just need a little clarity on.
Yep. So the question is, with a married couple, how do we look at this trustee role, trustee situation? Most of the time, each spouse would be the backup trustee for his or her spouse. Yep. So we're not getting to a child or some other trustee unless both spouses are gone. Or I have seen some situations where as parents age, they might say, I think my son or daughter's in a better position than my spouse is to manage things financially if I'm gone. Right? If we have a spouse with an Alzheimer's diagnosis or a dementia diagnosis, maybe we don't want them to be trustee anymore and let's just have a child do it instead. But generally, spouses will be trustees for each other. Yep. The other concept that we see from time to time is a support trust. So if you have assets you're protecting for young or foolish or young and foolish beneficiaries, you'll see something like this where we can hold the money in trust, maybe for a grandchild, use it for their health and education and support until they're older and more responsible, and then we'll give them some of the money as they age and get to a point that they can responsibly handle that. Okay? The benefit of using this sort of a trust for young beneficiaries is it protects the assets from foolish spending, creditors, bankruptcy, any other issues that they come across. Okay? Let's talk about taxes a little bit. Usually, when someone brings up taxes and you see a chart going up and up and up, it's a bad thing, right? Well, not the case in this chart, because this chart represents the amount of money you can have in Minnesota before you have to worry about estate taxes. Okay? So right now in Minnesota, upon your death, the first $3 million passes to your beneficiaries free of Minnesota estate tax. It's only anything over $3 million that's taxed at about 9 to 16%. Okay? At the federal level, you can have nearly $13 million as an individual or $26 million as a married couple before you have to worry about federal estate tax. So if somebody's telling you stories about how worried they are about the federal estate tax, don't feel too bad because they're doing all right, I think. But anything over that 13 million or 26 million is taxed at 40%. So when you do have those really high net worth estates where you've got Minnesota liability and federal liability, you could be talking about 55% of anything over 26 million. But once again, you're getting up there. There's a lot of information on this next slide, and I'm gonna breeze through it a little bit. The most important thing is to realize that IRAs are special when it comes to how we leave them to beneficiaries. And so it's important that you're working with your financial advisor or estate planning attorney to figure out the best way to structure beneficiaries on your IRAs. Because depending on who you're leaving the IRAs to, there are different rules for how fast the money comes out and therefore how quickly the money gets taxed. So this really becomes an issue. If you've got all adult children that you're leaving IRAs to, that's fine. That's simple. You list them as the beneficiaries and you're good to go. But if you want to leave IRAs to a trust to protect them for an irresponsible child or grandchild or a child or grandchild with a disability, then it gets much more complicated and we're diving into a lot of these different rules. So just be mindful with your IRAs to make sure you're getting advice on how to handle those beneficiaries where you have more unique circumstances. Okay? Sure, yep. I can try. My presentation only goes one direction. It just is forward. We've already been there, yeah. Yep. Yes. So in I don't want you to read this as saying, well, gosh, I don't want to trust then because it's going to be taxed higher. For income, as a trust generates income, it moves up the income tax ladder much faster than an individual does, right? So for an individual, you've got to get to whatever it is, $300,000 to pay taxes at the highest individual rate. For a trust, after about $12,000 or $13,000, the trust is paying taxes at the highest individual rate. However, the way most accountants handle that, and to be clear, I'm not an accountant. This is not tax advice. I'm an attorney. But how most accountants handle that, though, is you can pass the income through to the beneficiaries, and then the beneficiaries pay income tax at their rate, so you're not dealing with the trust income tax rate. So it's pretty neutral from a tax standpoint, but yes, if a trust is generating income and keeping all of the income in the trust, then you've got to worry about these higher rates. And it does not apply to the person creating the trust during your life, right? So if you just create a revocable living trust as part of your estate plan, like we talked about earlier, you don't have to worry about any of these higher trust rates because during your life, the trust operates under your Social Security number. It's only after you pass away and the trust becomes its own entity that we've got to look at that income. And it's 99% of the time not a problem. It's just where we've got situations that we can't distribute income to beneficiaries that we run into that issue. Yep.
Would there be a consideration then to actually the married couple or whatever to take that money out and pay the income tax on it as they're growing older? Because generally as you're growing older, you don't have that much income coming in.
So, yeah, I mean, the question is, should an older couple start to pull money out of the IRAs, start paying taxes on it now, maybe at their lower income tax rates, understanding that their kids may be in higher income tax brackets when they inherit from them? That is a great question for your financial advisor. It's specific to your situation, your tax bracket, your kids' tax brackets, kind of the future of where people think taxes will be at the point that they would inherit from you. But I know I've talked to a lot of financial advisors that will use that strategy and start converting some IRA money to Roth and paying taxes on it now as it makes sense. But that's really an individual analysis that should be done. Yeah, don't go cashing out your IRAs because some attorney told you to do it. Talk to your accountant, talk to your financial advisor. But it is a strategy I've seen people use. Yep, for that reason. I think we're still going backwards now. We got on the backwards train and now we're just going backwards. All right, no, that's fine. The one other thing I'll bring up, I'm not going to go back a slide because you saw what that does, but with IRAs, for those who are, charitably inclined, who want to give to their church or give to other charities, IRAs are an amazing way to do that, okay? Because when you leave an IRA to an individual, like a child, they're going to pay income tax on every dollar that comes out of the IRA as they pull that out. If you want to make charities or church part of your estate plan, leave them as a beneficiary on your IRA, because the church or the charity, if they're tax exempt, won't pay any tax on that money coming from the IRA where your kids would. So when I work with clients who are charitably inclined, we try to figure out which bucket we want to do the charitable giving from and which bucket we want to dedicate to the family. So, right, you leave the house and the life insurance and the bank accounts to the family, and you leave more of the IRA to the church or charity. And it really amplifies your gifting power. Okay? All right, let's chat a little bit about elder law. I think it's a really important concept, especially in light of what we're talking about here. So, what is elder law? And I think I'm maybe uniquely positioned to talk about this because I've both been not an elder law attorney and now I am an elder law attorney. Right? So I've seen kind of both sides of this coin. So I look at elder law is dealing with a lot of issues that basic estate planning attorneys don't handle. And most of it revolves around how are you paying for long-term care? Right? What happens if you or your parents or your sibling goes into a long-term care facility and now it's costing $8,000 to $10,000 a month to pay for that care that they need? How do we protect assets? How do we ask the right questions of the facilities as we're trying to find the right facility for mom or dad or spouse? Okay, what does that process look like? So in my mind, elder law is navigating all of those issues that come along with aging, Alzheimer's, dementia, long-term care, and all the government benefits that surround all of those issues. So the next question is, how do you know when to call an elder law attorney? And for me, there's really two different scenarios, and the first is diagnosis, okay? When somebody receives a Parkinson's, Alzheimer's, dementia, MS, any diagnosis that makes them much more likely to need long-term care. And I would say even as part of that, I would consider diagnosis, mom or dad's memory starting to go, right? Maybe they don't have an official Alzheimer's or dementia diagnosis, but as you start to see some of those significant memory issues, not like, why did I come into the kitchen? I don't remember what I came here for, but those more impactful memory loss issues, that's when you should be talking to an elder law attorney. Because on the front end, there's a lot more that we can do, right? With elder law, the more time we have, the more flexibility we have, and the more capacity we have, right? If the person I'm helping has capacity, we have a lot more flexibility than if they don't. So when we get that diagnosis, that's the time to be proactive and get a plan in place for the future. The second scenario, when you need to contact an elder law attorney, is when you start to look at long-term care facilities. So I would say that's maybe the more reactive version that, okay, now we're taking mom or dad to go visit all these different facilities and realizing how expensive they are and realizing we don't know how to pay for them out of their current assets. That's definitely red flag. Talk to an elder law attorney, usually before you decide on a facility, because what I do is help people understand what questions to ask of the facility in the first place. Right? It's really helpful to know if the facility accepts medical assistance elderly waiver. That's a critical question to ask. Maybe the facility's all private pay. Maybe they've got a 2-year private pay requirement. Do they have an MA bed available, right? Those are all the questions we need to ask before we decide on a place. Because we don't have to move our spouse or move our mom or dad multiple times once we get them settled into a facility. So those are the two scenarios when I think you should lean towards meeting with an elder law attorney. A couple other pieces that are unique to elder law. One is this document called the Common Law Power of Attorney. This is something that before I started practicing elder law, I did not prepare for my clients because I didn't see the value. I didn't know why this document was so important. So with a lot of attorneys out there who are drafting wills and trusts, or maybe a generalist attorney, they may not even know this common law power of attorney exists, and they may not be putting it in place for their clients. But what this document does is, first off, it covers everything a basic power of attorney covers. So my clients will have both. They'll have a basic standard power of attorney, and they'll also have this common law power of attorney. The biggest benefit when it comes to elder law is the common law power of attorney gives families way more flexibility when it comes to long-term care planning. And that's mostly gifting power, right? The ability to move large sums of money from your parents into your name, from your name into your spouse's name, all as part of trying to preserve assets for long-term care. It gives us way more flexibility than a standard power of attorney document. It also allows these people to make decisions based on what's in the family's best interest, not just the person who needs long-term care's best interest. Because frankly, if my spouse goes into long-term care, it's never in her best interest to move everything into my name to protect what we've built together. That's not in her best interest. That's in my best interest or the kid's best interest. So that's where the common law power of attorney allows us to do things that my wife would do if she had capacity, but doesn't, right? That's the flexibility we have there. Okay, so it's once again, a really powerful document, but I draft it for every one of my clients now because I've seen what happens when we have that flexibility and when we don't. And I'd much rather have that flexibility. Yeah.
Is there a 5-year thing that you have to do this before?
Yeah, the question is there a 5-year look-back period? The answer is yes, but I will talk about that in a few slides too. So we'll get into that a little bit more as we get into the nitty-gritty. So common programs, if you or a parent or spouse is moving into a long-term care facility, there are 2 different programs that most people fall under, kind of setting veterans benefits aside. One is medical assistance for long-term care, and the other is medical assistance for elderly waiver. In both of those situations, the person who's going to receive benefits need a nursing facility level of care, right? So they need to have either some physical ailment that requires that they need a nursing facility level of care, or memory issues also fall into that bucket, right? We see that more and more, that memory issues are kind of the easiest ticket to qualify for those programs versus needing to dive into what your physical ailment prevents you from doing on a daily basis, okay? The big difference between elderly waiver and medical assistance for long-term care is medical assistance for long-term care can only happen in a skilled nursing facility. So in the state of Minnesota, there are only a certain number of beds or rooms that are technically considered skilled nursing facilities. Elderly waiver can happen in any other assisted living community or housing with services community. So we're seeing by far more people receiving care under elderly waiver because that could be anything from in-home support all the way to memory care. It's just a much more wide range of support, and the long-term care MA is limited, okay? But the programs operate pretty similarly. So the next thing you need to qualify for medical assistance is you need to qualify from an asset standpoint, okay? If you are a single person, generally, you're allowed to have $3,000 in assets and be able to qualify for medical assistance. So as you hear people talking about spending down to qualify for medical assistance, they're trying to take their $200,000 in assets and spend it down to $3,000 total. There are some exceptions that I'll talk about in a little bit, but that's the general idea. For a married couple, the spouse receiving care, I'm going to refer to that person as the MA spouse, can also have $3,000. But the community spouse, the spouse not receiving medical assistance, can have $148,620 in additional assets if they're not receiving MA. So that's where we've got some flexibility to protect assets for the spouse that's still living in the community and still needs money, right, to pay their bills and exist outside of the long-term care facility. If both spouses are on MA, they can each have $3,000 total. Okay? Yeah.
You're probably getting to it, but when you say that in assets,
Yep.
in defining the assets, does that exclude like the home or exclude certain things?
Yes.
Cash, does it
So,
exclude like an IRA investment?
yep, there are a lot of, the question is, what other assets might be excluded or allowed to hold on to while someone's receiving MA? And I'll dive into that now. I think one thing I want to mention, though, is every elder law situation is incredibly unique, right? I mean, I think it's probably the most unique aspect of my job is as families come in with elder law issues, there are so many different variables, so many different circumstances that one solution is not going to work for everyone. So if you're, talking around coffee and donuts after church one day and someone says, "Oh, I just transferred the house to so-and-so and now I'm able to qualify for medical assistance," or "I just moved everything into an irrevocable trust, now I get to qualify for medical assistance." Don't assume what worked for them in their situation will work for you and your family. It's a really unique individual determination that happens with every family, okay? So just be careful of these coffee conversations that people always bring those into my office. We're sitting around coffee and so-and-so protected their house and I want to do that too. It's like, well, I don't know anything about so-and-so's situation, but it's not going to work for you, right? So keep that in mind. So the question was, what else can we protect and still allow someone to qualify for medical assistance? As a single individual, you don't have a lot of flexibility to protect assets. So, you can have your $3,000, you can have one vehicle, regardless of value, as long as that vehicle is still being used to take you to and from appointments and essentially provide support for you. So, you could have a Maserati as your one vehicle and protect a couple $100,000. No one's taken me up on that yet. I'm still waiting for the client to say, "Yep, that's what I'm going to do." But so you can have the one vehicle regardless of value. You can also have prepaid funeral expenses. So if a lot of people are trying to spend down their assets to qualify for medical assistance, one of the first things we do is to make sure their funeral's paid for, usually with an irrevocable life insurance policy through the funeral home. A couple things to note about that. Some people think, "Oh gosh, well, am I stuck with that funeral home if I buy that policy with them?" No. The way most of those irrevocable life insurance policies are set up is you can take that policy to any funeral home, or your family can take it to any funeral home they want upon your death. So just because you planned with Washburn McCreevy, for example, doesn't mean your family has to go with them when you pass away. So you're not locked down with anything just by pre-planning. But as we meet with families, usually pre-planning is one of the first things they do because, one, it's a guaranteed way to protect $5,000, $10,000, $15,000, $20,000 of assets. Also, it takes the burden off of the family of trying to come up with that money when you pass away, right? So you've guaranteed that everything's set as far as the funeral is considered, okay? That's kind of it when it comes to an individual. The $3,000, the car, the funeral planning, personal property. You can have as much personal property as you want when it comes to, jewelry and stuff around your house. If you need to buy maybe a new bed that's more comfortable for the person or more accessible for them, maybe an accessible recliner, you can buy personal property to help benefit their life. But that's kind of it as far as what you can protect. The homestead is protected as long as the person's living there or likely to return to living there. So usually at the point that we need that level of long-term care, they're not living in the home anymore. They're not able to live in the home anymore, so it's not protected. With spouses, we have a way more flexibility, okay? So I feel like a lot of the opportunities in elder law, long-term care planning, come with married couples. Because we can protect the same thing, right? The $3,000, the vehicle, funeral planning. We also can protect the house. Up to, I think it's over $600,000 now is the value of a house you can have and protect it from a long-term care standpoint. So as long as the healthy spouse is still living in the house, that's protected from a medical assistance standpoint. Okay? In addition, if we had an extra pot of assets, so maybe, mom and dad had an extra $400,000 in their retirement accounts, investment accounts, things like that, but now dad needs to move into assisted living and we're trying to find ways to protect things for mom, we can take that $400,000 and turn it into an annuity for mom for the next 4 or 5 years. Okay? So mom can keep her $148,000 on top of everything I just talked about, and mom can have an additional $4,000 a month coming in from an annuity, because income and assets are viewed differently from a medical assistance standpoint, right? The other thing to keep in mind, and this is kind of interesting, they only look at the community spouse, so mom in my example, they only look at her assets once, at the time of the application, at the time that dad qualifies for medical assistance. From that point forward, mom can continue to build her assets. So if mom got a job and she was bringing in money, or if mom had an annuity that was paying her money every month, mom's assets can go from $148,000 all the way up to $700,000 or whatever number and not impact dad's eligibility. They only look at mom's assets at the time dad applies, and then they don't care about her assets ever again until she passes away. So there's a lot we can do to make sure that the spouse who's living in the community, who doesn't need medical assistance, has all of these assets protected for them, and they've got a quality lifestyle for the rest of their life. Right? I want to talk briefly about the 5-year look-back period, and then maybe I'll wrap the official presentation and then stick around for 5-10 minutes for questions. So there is a 5-year look-back period in the state of Minnesota right now, which means if you apply for medical assistance today, they're going to look back and say, have you made any gifts, regardless of value, over the last 60 months? And if the answer is yes, you gave away $100,000 over the last 60 months, they're going to penalize you. So you don't get to qualify for medical assistance for another 10 months. Okay? So they essentially take the amount of money you gave away over the last 60 months, divide that by the average cost of care, which is about $10,000 a month, and then they penalize you for that many months. Now, some people say, gosh, well, why don't I just give away all of my money now and then just wait the 5-year period and then I'll be good? Well, one problem is, what if you don't need long-term care? You don't want to give everything away that you need to pay your bills, enjoy your retirement, everything else. So if we had that crystal ball that we were talking about before, and we knew we were going to need care in the future, it might be a little bit easier, okay? But if we don't know that, most people want to retain control over their assets to provide for themselves as long as they can, okay? The other issue with giving everything away now, knowing or thinking we can make it the 5 years, is what if it's no longer a 5-year look-back period? The only time I can tell you there's going to be a 5-year look-back period is if you want to apply for care today. I 100% guarantee it's going to be a 5-year look-back period if you apply today. If you want to apply a month from now or a year from now or 2 years from now, I have no idea what the look-back period is going to be. Could be 7 years, could be 9 years, could be 15 years. We have no idea. The other thing when you look that far out is we also don't know what government benefits are going to be like that far away, right? So maybe 10 years from now, Medicare covers long-term care, right? We have no idea if that's going to be on the agenda in 5, 10, 15 years. So I think it's difficult to look that far in the future and try to figure out what's going to be covered and what's not and how government benefits are going to work. So that's why I really focus my efforts on a diagnosis where we know it's relevant for you now, or looking at facilities now, right? When you're making that move, now we can plan based on the rules that are in place. Okay? All right, so I'm going to wrap. In your folders there, I gave you a copy of the slides. There's also a meeting request form. So with any estate planning, I do a free initial consultation. If anyone's interested, you could fill out that form and just leave it up here before you leave today, or you can reach out to our firm otherwise. But I will open it up for questions for the next couple minutes and go from there.